Have you ever wondered if you could just stop a court case? I don't mean winning it. I mean stopping it cold by challenging its very right to even exist. Well, today we are diving into a really fascinating document that claims you can do exactly that, all by using a very specific set of words and questions. Let's get into it and see what this is all about.
So this is the big question, right? The central claim of the document we're breaking down today. It basically argues that if you use the right language, you can challenge the entire nature of a court and just bring the whole thing to a grinding halt. It's a pretty radical claim, so let's explore the framework it's actually proposing.
The source for our explainer today is a document called 62 Plus Ways to Shut Down a Court Case. Now, a really quick but super important heads up. We are absolutely not giving you legal advice here. Our goal is just to dissect and understand the very unconventional strategies and the worldview that's presented in this text.
To make sense of all this, we've organized the document's tactics into 5 main themes. First, we're going to look at questioning the court's basic authority. Then, we'll see how the script tries to turn the tables on the judge. After that, we'll explore these so-called magic words that supposedly have special power before diving into the main idea of declaring your own personal sovereignty. And finally, we'll look at the script for handling a contempt of court charge.
Okay, first up, challenging the court's foundation. The idea here isn't to argue the facts of your case, but to question the very ground it's built on. These tactics are all designed to undermine the court's authority before anything can really even get started.
So these questions are all designed to poke holes in the court's procedural legitimacy. Asking, is this a court of record? Or where's the victim? Is meant to challenge the court's legal standing. But the question about the tax ID number, that one's really interesting. It's trying to reframe the court as a for-profit corporation, which, in this worldview, has no power over you unless you willingly enter into a contract with it. And that leads us right into the second strategy, putting the judge on trial. The thinking is, if you can't undermine the court as an institution, the next move is to question the personal authority and the impartiality of the person who's running the show.
This is a direct confrontation, right? The source suggests that by making the judge confirm their oath to the Constitution, you're putting them on the spot. It's all about getting their commitment to uphold constitutional principles on the record, right then and there.
This next question takes the challenge even further. By asking, are you practicing law from the bench? The document is suggesting the judge has actually crossed a major line, that they've stopped being an impartial referee and to become an active player, which would compromise the entire proceeding.
Okay, this next section gets into a core belief of this whole system, the magic words. This is all about linguistic precision. The idea is that certain words hold a very specific, almost binding power that can completely change the course of a case.
According to this document, the word understand has a hidden meaning in court. It's not about whether you comprehend something. It's interpreted literally as to stand under the court's authority. So if you say, I do not understand, you're actually making a powerful statement rejecting the court's jurisdiction over you. You're basically saying, I do not consent to your power.
And that brings us to a huge pillar of this worldview, the straw man theory. So stick with me here. The idea is that your name, when it's written in all capital letters, like John Doe, isn't actually you. It's a legal fiction, a corporate entity created by the state. The living, breathing person, John Doe, is totally separate. The argument is that the court only has jurisdiction over that corporate fiction, not over the real human being.
And here's how the document suggests putting that theory into action. By directly questioning the name written in all caps, you're making it clear for the record that legal fiction isn't me. The whole point is to try and sever the connection between the flesh and blood person and the corporate straw man the court wants to charge.
Which leads us perfectly into our fourth section, declaring sovereignty. This is really the ultimate goal of a lot of these tactics. It's all about establishing yourself as a sovereign, an individual who isn't subject to the court's authority at all, unless you explicitly agree to be. So the source claims these questions come from the Uniform Commercial Code, or UCC. By asking the judge, do you have a claim against me? You're trying to reframe the whole case in commercial terms. The logic is pretty simple. If the court is a commercial entity, then it needs a commercial claim. If nobody in that room has a direct personal financial claim against you, then, according to this theory, the corporate court has no basis to proceed.
This quote really captures the philosophical endgame of the whole sovereignty argument. It's a rhetorical challenge, right? If a person is truly sovereign, they don't need the state's permission to do things. Therefore, they can't be forced to get a license or follow regulations they haven't personally and explicitly agreed to.
All right, for our final section, we're looking at a very specific script for what the document presents as the ultimate courtroom challenge, defeating contempt of court. This is a detailed, step-by-step guide for how to respond when the court uses its most direct and powerful tool against you.
The document lays out this very structured 7-step process. It's not just about yelling, "I object." It's a systematic escalation designed to challenge a judge's ruling at every single turn and make sure that every part of that challenge is officially on the record. The goal is to create a procedural minefield for the court to navigate.
And the document makes a really crucial distinction here. It says you have to immediately force the court to clarify if the contempt charge is civil or criminal. If it's criminal, the script challenges the very basis of the crime. Who's the accuser, what's the crime, and who's the victim? But if it's civil, the response snaps right back to that core theme of contract law, asking, where is the contract? Framing the whole thing as a voluntary agreement that you are now officially refusing.
So when we piece all these different tactics together, this consistent worldview we've been tracing comes into full focus. From this perspective, the legal system isn't some inherent authority that just exists. No, it's seen as a commercial, contract-based entity that absolutely requires your active, voluntary consent to have any power over you at all.
And that really brings us to our final thought. All the strategies presented in this document are built on one central idea, that legal authority is based on consent. Which leaves us with a pretty powerful question to think about. If authority really is a form of contract, what happens when one of the parties simply refuses to sign?